Hi, my name is Breanne Grey. I'm an attorney at the Nieves Law Firm. I practice criminal defense. I'm here to start the first of my series of videos, which are going to explain how crimes are charged and prosecuted. I have with me an example. This is what we call jury instructions. You need the jury instructions at every trial, and within the jury instructions are elements. Every crime has a certain amount of elements, and every element of every crime has to be proven beyond a reasonable doubt at trial. The same thing happens at a preliminary hearing, which is like a mini trial when the prosecution essentially presents all the evidence they have. You have the same jury instructions, but for a preliminary hearing, each of these elements only need to be proven to a probable cause standard. So it's a lower standard, which makes it easier for the prosecutors, and then we get to trial, and then the standard becomes a lot higher, and then the standard is beyond a reasonable doubt. And so that's where we would come in with criminal defense strategy, and we would essentially mold our strategies around all of these jury instructions. So my example here today is the offense of Penal Code Section 25400A1, carrying concealed firearms within a vehicle. And so this particular crime has 4 elements. Each of these 4 elements need to be proven beyond a probable cause standard at preliminary hearing and beyond a reasonable doubt at trial. And I will, over the course of this series, show you a whole bunch of different types of jury instructions, and you'll find that some jury instructions, some laws, are a bit more flexible than others. Firearms charges in particular are a bit strict, so I think it'd be a good place to start with explaining something that is a bit less flexible in how a court would interpret. So the 4 elements that need to be proven by the prosecutor to charge someone or to prosecute someone with carrying a concealed firearm within a vehicle is that the defendant carried within a vehicle a firearm capable of being concealed on a person. The second one, the defendant knew the firearm was in the vehicle. Third one, the firearm was substantially concealed within the vehicle. And the fourth one is that the vehicle was under the defendant's control or direction. So each of those 4 things have to be proven, and each of those 4 things essentially have their own body of law that surround them. And so one thing that we do certainly always want to look at is with every element, there are certain buzzwords. With every buzzword, there comes a body of law behind it, such as what do these certain things mean? Like what is a firearm capable of being concealed on a person? This particular instruction defines it as something that has a barrel of less than 16 inches in length. So not like a rifle, 16 inches is about yay wide. Anything less than that, so a pistol, a Glock, handgun, those are all things that this particular body of law covers. What does it mean when something is substantially concealed? Well, these instructions actually specify that even a gun in a lockbox that's not locked is going to violate this particular law. So in order to transport a firearm in your vehicle, it needs to be in a locked lockbox. That's how you get around that. There are some other things here that are a bit strict, such as a firearm doesn't even need to be in working order to qualify under this jury instruction or under this penal code statute. So even if you have like an ancient gun, a collector's item, something like that, something that is busted, something that doesn't work, if it's not properly stored in your vehicle in a locked lockbox, it can violate the law. And one of the other instructions I mentioned, the vehicle was under the defendant's control or direction. That can be interpreted as either the person who's driving the vehicle or maybe the person who owns the vehicle, but they're not driving. They might be in the passenger seat, but they own the vehicle and it's under their control or their direction. And so essentially what this means is that if you are driving a vehicle and it's not even your vehicle, say you're borrowing your friend's car and there is a weapon in the back seat that you know is there, you are responsible for that weapon because you're the one who is in control of it. So there are some things that the prosecutor will always consider in trying to press these charges or prosecute you for this type of crime, such as whether or not the defendant knew that the firearm was in the vehicle. say you knew the firearm was in the vehicle, say it's your vehicle, say you're driving, say your friend gets in the car. And your friend gets in the car, they bring a gun into the car, into the backpack. You know the gun is there, it's not your gun, it's your friend's, you didn't ask for the situation, but you knew the gun was there. That alone is enough for the prosecutor. That alone is enough for a probable cause standard to bring you to trial on this type of charge. So there are some other things that you want to consider, like the defendant does not have to have exclusive possession or control of the firearm. So some of these gun charges are a little bit tricky. They're a little bit hard to defend, but we here at the Nieves Law Firm are here to help. We know the things to say, the things to argue, the things to pick apart. We know the right prosecutors and the right cops and the wrong prosecutors and the wrong cops. We know how to navigate these things. So if you or a loved one has had issues with gun offenses in the past or in the present, or you're worried about something that might even happen in the future, please give us a call. Or visit our website at thenieveslawfirm.com. Thank you.